not going to appear on the Zoom link. The phone link is still the same, and the passcode and the meeting ID are still the same, and it's quite a bit of numbers. Do you have an email that I can email this to you so that you would have it, so you can call in with all the information?
No, I have a pen and paper here, though. You can give it to me.
Okay, so you don't have an email where I can email this to you with all the numbers so you'll have it?
No.
Okay.
I've got a pen.
The phone number is 1-346-248-7799.
Okay.
The passcode is 309128.
Mm-hmm.
And I'm not sure if you need the meeting ID also. It is 839-4672-6996.
Okay, so that was the phone number, the passcode,
and the meeting ID. So you'll need to call in within the next few minutes to make sure it works. Otherwise, because you said you don't have an email for me to email this to you.
Right. So I'll try to call in right now.
Okay.
All right. Thank you.
Thank you.
Followed by pound. Enter your participant ID followed by pound. Otherwise, just press pound to continue. You are in the meeting now. There are 5 participants in the meeting. You are muted. You can mute or unmute yourself by pressing *6. You are unmuted.
Hello?
You're on, ma'am. Just give us a minute, okay? Thank you for calling in.
Thank you.
All right, let's go on the record here. Good morning, everyone. I see Mr. Bays is here, Bays Firm, and there's a number. There's a couple people. Looks like there's a few phone numbers that have called in. 713-494-4727. Whose number is that?
NannetteCarley.
Okay, great. That's what I was trying to confirm because we are in a Zoom hearing. Miss Carley, I just wanted to confirm this is actually you for the purpose of the hearing. Doing so, who did you speak to at my office to get the link?
I'm sorry, I have an adopted sick dog in the background. What was your question?
All right, you're going to need to remove that dog from
Yes,
the area.
yes, I'm trying right now, sir. I apologize.
Oh, no, don't worry about it. Thanks for doing that.
Okay, I apologize.
Don't worry about it. I appreciate you removing that the dog so we can get through this here together. Let's see here. So let me get your information here. So for the record, Miss Carley Miss NannetteCarley moved with the court, petitioned the court so that she could appear via telephone. She does have, I know she spoke with my staff attorney, she does have an email, but's reluctant to give it out.
I've been having email and a computer and electricity problems, so I didn't want to have to rely on any of that.
That's fine. I'm just making the record clear that the court granted your request to appear via telephone.
Yes.
In the clerk's file, Miss NannetteCarley's information within the court's file for this cause number, by the way, we're on the record, 2012-14893, Sol Vector Inc. versus NannetteCarley. Miss Carley's telephone number in the system is 713-494-4727. That is the same phone number that appears before the court in this hearing. Miss Carley has introduced herself. Why don't you go ahead and introduce yourself again, ma'am? Let us know who you are for the record.
NannetteCarley, defendant.
Okay, great. And Mr. Bays, why don't you go ahead and introduce yourself and your client?
Morning, Judge Santini. This is Randy Bays here on behalf of Salwisher Inc. And Salwisher Inc.'s corporate representative is David Salwisher, who is seated to my immediate left.
All right, sorry, I mispronounced. I said Sal. I was doing some German pronunciation. Oh, Webster. Like what's that sauce that you cook with? Worcestershire. Yeah, Worcestershire. I probably couldn't spell either of those. So there's that. Okay, great. So we are here. And I wanted to put a couple more things on the record. So the court did grant Miss Carley's request to appear via telephone. The court has established, because I can't see her, but I've never met her before, but the court is comfortable that the person on the other line is Miss Carley, because she's been in contact with my staff on how to do this, and we got her hooked up, and she's here, and it's the right phone number. Second, the court received a filing from Miss Carley of a motion to disqualify the court or any Montgomery County court for presiding over this matter because Judge Kristen Bays is Mr. Bays' wife, and I think she handled the underlying tax suit in this matter, the 1711-13325 cause number. There was also some language in there, motion to recuse. So the court treated it as both a motion to disqualify the court as well as a motion to recuse the court. I denied the request to disqualify, and I declined to recuse myself and referred the motion, Ms. Carley's motion, to the administrative judge for the second region, Mr. Judge Olin Underwood. Judge Underwood did not, he already ruled on this without the need of a hearing. He found yesterday that the motion was not in proper form, and he denied the request. We could not email the request to Ms. Carley, so we sent it, or we didn't. Judge Underwood's office mailed it to her, as well as filed it with the clerk, and I think they emailed Mr. Bays a copy at the same time they mailed Ms. Carley a copy. So that has also been taken care of. So I am able to decide over this matter. And that being said, let's go ahead and move forward. We are here. Mr. Sol Wester, I'm going to butcher that name all day, but this has been, there's an application for temporary injunction for the pendency of this litigation. The court has read the application. The court has read the response. The court has viewed the attachments. The court has also done research, in particularly with the jurat 365 Southwest 3D 314, the Mansions in the Forest LP, and the Estates Woodland LP petitioners versus Montgomery County. our county Supreme Court case, and it is dead on. Actually, you probably can't find a better case dealing with the jurat issue in this matter. It was actually similar form, acknowledged by and not sworn. So, go ahead, Mr. Bays.
Well, the first thing I have, Judge Santini, is a little housekeeping matter. There's another person that's got this phone number.
Yeah, and there's another one. Can those people? So let's start with
Your Honor.
with that.
Your Honor, those are my communication aids.
Oh, okay, and that's fine that they're here. I just want to know who they are. So who's that?
That's my communication aid, Your Honor.
Who is it? The name. What is their name?
Diane Carter.
Diane Carter. Okay, thank you. And then who is?
That is my other aide, Mr.
What is their name?
Mr. Cornforth.
Full name, please.
R. Cornforth.
Art Cornforth.
Initial R, L, initial R, initial L, Cornforth.
Okay, R.L. Cornforth. Got you. Thank you so much. All right. And they are muted, so I appreciate this is an open court, so they can attend. All right. So does that take care of that, Mr. Bays? Anything else?
Yes, I'll invoke the rule, Judge Santini. Who these people are, witnesses, what their role is.
Okay. And so right now the rule has been invoked. Ms. Carley, your communication aids, are they witnesses in this matter?
They are my reasonable accommodations for Americans with Disabilities Act.
Are they witnesses in this matter, or are they just aiding you to understand?
Yes, they're my communication aids to help me communicate because I become sometimes unable.
What does that mean?
It means
they're not speaking. They can't speak for you. So.
Well, as my communication aids, should I become unable to properly communicate, then I have communication aids to help me do that.
How do they do that?
Because they have been briefed on what I am attempting to accomplish, and when I become confused, they speak for me.
Okay, that's not going to happen. You're here, you are competent, so we can deal with that. We can deal with competency first, but they can't speak for you. You are the witness. And the only time someone can speak for you is if there's an interpreter, and they can't just step in and speak for you.
I was told by your clerk that you had approved my disability accommodations, one of which is a communication aid. One of my disabilities is I become unable.
Well, we will take if you become unable, we'll take a break. But I approved you attending via telephone. That was my accommodation. You didn't want to come in person. You didn't want to do Zoom.
Well, it's not that I don't want to, Your Honor. I'm unable.
Okay. Well, you're not able to have someone else speak for you if you're the witness. So, unless there's an interpreter.
I believe that's a reasonable accommodation, so I do object to that.
I made my ruling. Thank you. I made my ruling. You've been filing motions both in this case and in the 1711 case. You're articulate. You are aware of what's happening. I'm making all these findings that you're not incompetent. You are competent.
No, sir, I'm not claiming I'm incompetent. I'm claiming that I am sometimes unable to articulate
Well,
due to my
you have to articulate
disability.
the best of your ability. So no one will be able to speak for you other than yourself. There's my ruling. Okay.
I object.
Miss Carley, that's my ruling.
Thank you.
You're the only one being able to testify for yourself.
Thank you.
Okay. Mr. Bays, go ahead, sir.
Thank you, Judge Santini. The problem with this case is it is exactly backwards. We should not be the ones here seeking possession of our property. It should be just the opposite. What we have in this case is two different court orders that has recognized Sal Wisher's Inc. right to possession of the property. We start back, the evidence is going to show, we start back with the ruling from the tax court where Ms. Carley was sued by the Tomball ISD for failure to pay her ad valorem taxes, joined in by Montgomery County and several other entities. She lost those suits. The property was ordered sold. The property was sold by Constable Chris Jones on December 3rd, 2019. Sal Wisher Inc. made the winning bid.
Your Honor, I object to
No,
Mr.
ma'am,
Bays
what?
speaking. He's not a witness to this case, and I don't know that he's been sworn in to witness to any of these facts.
Okay.
He's also
All right.
speaking to facts
Okay.
which are not in the record.
All right, Ms. Carley, thank you for your objection. I'm overruling this opening statement. He's telling the court what he believes that the evidence will show in this hearing.
Thank
and
you.
I'll give you the same opportunity.
Thank you.
So right now, it's his opening statement. Thank you.
Thank you.
Overruled.
May I proceed?
Yes, sir.
Thank you, Judge. So we have the order out of the 284th District Court ordering the property sold. The evidence will show the property was sold by Constable Chris Jones to Sal Wisher Inc. And then the evidence will show that because Ms. Carley did not vacate, Sal Wisher Inc. did what the law requires him to do. Get a writ of possession from a court, having law enforcement put him in peaceable possession of the property, which is exactly what happened, which is exactly what occurred. Then the evidence is going to show that Ms. Carley reached out to Sal Wisher Inc. to learn what the redemption price for the property was. Those numbers were provided to Ms. Carley. Ms. Carley retained an attorney that communicated both with Mr. Sal Wisher and me. And then they simply just went away. Nothing more was heard from them. Then Ms. Carley, on her own, goes down and sees Tammy McCrae's people, takes in a sum of money which is woefully deficient for what she was required to pay in order to redeem the property, gives that amount of money to the tax assessor collector, and gives some document that purports to be an affidavit, which is not, it does not contain the jurat. Then she takes that instrument, records it in the real property records, and then attempts to get possession of the property. The constables are called. The constables talk to Mr. Sal Wisher. The constables talk to me. And they inform Ms. Carley that it is incumbent upon Ms. Carley that if she wants possession of this property, she must get a court order putting her in possession. The evidence will show that Ms. Carley then goes into Precinct 5 Justice Court, Judge Madsen, seeks an eviction proceeding, seeks a writ of possession, and that relief was denied for want of jurisdiction. Ms. Carley never appealed. If Ms. Carley had a ruling with Judge Madsen's ruling, her obligation was to go and appeal that to Judge Claudia Laird's County Court of Law No. 2 that hears all of the civil court appeals out of the JP courts. That never occurred. Instead, she just takes it in her own hands and moves herself into Sal Wisher Inc.'s home that she had lost at the tax sale and has refused to vacate. We've made demands that she vacate, and she has refused. So he came to this court, and so here we are asking this court to enforce the prior orders that are absolutely final. They're not subject to appeal. That orders that she cannot challenge. But yet here we are, and that's why things are just exactly backwards. We have possession. We have possession via the writ of possession out of the 284th District Court. Ms. Carley tried to get possession. The evidence is going to show that was denied when she went there. The evidence will show that she never appealed Judge Madsen's order, but yet she moves in and has put us in the precarious position of having to come to this court to get this court to enter a temporary injunction to get her out of Sal Wisher's Inc. property so they can have its property as it sees fit. I mean, Judge, there's no dispute. She's entitled to redeem the property. She has a 2-year period to redeem the property. But she has failed to do so. She has taken it upon herself by giving false information to Tammy McCrae. The evidence will show that she signed a document that does not comply with the statute, but it is not an affidavit, for it lacks a jurat. Obviously, Tammy McCrae's people were oblivious to that requirement of the law. They gave her this document, and therein lies the problem. That's why we have filed this lawsuit. We have done what we're expected to do. We're complying with the law. We're respecting the rule of law. We're not out there operating as Ms. Carley under some rule of me. And so at the end of this hearing, we're going to ask the court to recognize that Sal Wisher has the exclusive right to possess that property and to order Ms. Carley to vacate it, and if necessary, involve law enforcement to have her physically removed from the property yet again. Thank you, Judge Santini.
Okay, thank you, Mr. Bays. Go ahead, Ms. Carley. You will have an opening statement as well, if you would like. It's your right to do so.
I would. First, I would like to object to Mr. Bay's statements that the property is Sal Wechter's property. The property records in the county reflect that it is my property, that it has been properly redeemed. The property was sold at tax sale. It was ordered for tax sale on a default judgment while I was unconscious and sold on December 3rd of 2019. I did not find out it was sold until April of 2019 and was forced to move in April of 2020. And I was forced out of my home in June. I did contact Mr. Sal Wechter to find out what fees were due, and Mr. Sal Wechter returned expenses that were not allowed within the law, such as removing my air conditioner, which was still under warranty, and replacing it. And he was demanding sums of money for expenses that lie outside of the law, which is allowed in the tax code chapter 34, tax sales and redemption. Under such, he's only allowed the amount reasonably spent by purchaser for maintaining, preserving, and safekeeping the property, including the cost of property insurance, repairs or improvements required by a local ordinance or building code, or by a lease of the property in effect on the date of sale, discharging a lien imposed by a municipality to secure expenses incurred by the municipality in remedying a health or safety hazard, dues or assessments for maintenance paid to a property owners association under a recorded restrictive covenant, one moment, Your Honor.
No problem.
I'm having difficulty.
Yeah, I think you're referring to 3421.
2G2. recorded restrictive covenant to which the property is subject, or impact or standby fees imposed by other local government or water codes paid to a political subdivision. The expenses that Mr. Salwechter were trying to collect were far outside of what's listed in acceptable or approved costs. This included the cost for Mr. Salwechter to destroy the food forest for the church that was on my property, my food forest, removing, as I said, the AC under warranty, gate battery under warranty, and so under the property code, since Mr. Salwechter would not agree to the expenses allowed by law, I followed the property code and redeemed it per, I believe it's the same section, 3421, which says that I may redeem the property, and that we read it directly from the code. One moment, I'm having trouble communicating reading. One moment, please.
It's F. It's section F.
I'm just having trouble speaking, reading. One moment.
And the record is clear that your speaking ability is spot on. You're speaking just fine.
Thank you.
Welcome.
Okay. It states, the owner has made, the owner of a real property sold at tax sale may redeem the real property by paying the required amount as prescribed by this section to the assessor collector for the county in which the property was sold, if the owner of the real property makes an affidavit stating that the period in which the owner's right of redemption must be exercised has not expired, that the owner has made a diligent search in the county in which the property is located for the purchaser at the tax sale or for the purchaser at resale and has failed to find the purchaser, that the purchaser is not a resident of the county in which the property is located, that the owner and the purchaser cannot agree on the amount of redemption money due, or that the purchaser refuses to give the owner a quitclaim deed to the property, which Mr. Salwechter and I did not agree on the amount, and he therefore was refusing to give a quitclaim deed. Therefore, under section F1, an assessor collector who receives an affidavit and payment under section F shall accept that the assertions set out in the affidavit are true and correct. The assessor receiving the payment shall give the owner a signed receipt witnessed by two persons. The receipt, when recorded, is notice to all persons that the property described has been redeemed. Now, I did this I went to the assessor collector. I paid what was owed, which was Mr. Salwechter's actual expenses plus 25%, and I recorded that in the county recorder. I then went to the property to take possession, and Mr. Salwechter was at the property. He demanded that my locksmiths leave. I arrived and demanded that he leave. He demanded that I leave. I called the sheriff. The sheriff called the constable. The constable and Salwechter were both handed the stamped copies from the clerk of records, the county clerk, duly stamped, which was notice to all that the property had been lawfully redeemed. At that time, the constable ordered me off of my property under threat of arrest, and I left the property. I then reached out to my legislatures. I did as the constable told me at the time that I had to do, which was file a forcible entry and detainer with the justice of the peace. I explained to the constable that nobody lived here, therefore I couldn't file a forcible entry and detainer because that's an eviction action against tenants. But the constable said that was the only way I was going to get back on my property. So I did file the action, and as Mr. Bay stated, the action was denied for want of jurisdiction. There was nobody living in the house, and I was already the lawful owner. I then reached out to my legislatures, the county assessor collector and the clerk of records, who the county attorney stated that the constable should have never asked me to leave my property. The evidence will show this. The evidence will show that the clerk of records said the property is lawfully mine and I should have never been removed. So after that, in February, let's see, and I'll give you an exact date on January 19th, I came to the house to again attempt to occupy my property that was in my name and had been lawfully redeemed. I called the constable on that date and told him I was entering my property, and if he wanted to arrest me, he could come do so. He did not show. And then, as the record shows in this court, Mr. Salwechter called the constable on the same day, claiming that it was his property and he wanted back on and wanted me removed. And the constable told him that until the county attorney told him he could get back on the property, he was not allowed. The property has been lawfully redeemed. The property is mine, and Salwechter is seeking unjust enrichment. I have no contract with him. I have no obligation to him. The property has been lawfully redeemed, and once I regained entry to the property on January 19th, I could not even begin to move in until after February 2nd, because Mr. Salwechter had then removed carpeting and other items that I saw in the house when I came on November 4th. When I came on November 4th, Mr. Salwechter was doing something at the property and the doors were open. He allowed me in. I walked through. I saw carpet missing, but I saw some carpet still here. I saw the remote control to the pool, and I saw the pool cleaning machine. When I came back and occupied the property on January 19th, those items were missing as well. So,
all right, well, thank you so much. It sounds like you got a lot to present, and I appreciate it. Mr. Bays, call your first.
I'm sorry, Judge. I was on mute. I'll call David Salwechter.
Yeah, Mr. Salwechter, please raise your right hand. Do you solemnly swear or affirm the testimony you'll give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, sir, I do.
All right, now, Ms. Carley, right now it's Mr. Worcester. He's going to be testifying. Mr. Bays will be asking him questions. When that examination is through, you will have a chance to ask him questions. Okay, ma'am?
okay.
All right, Mr. Bays, go ahead.
Thank you, Judge Santini. So if you would, state your name for the record.
David Salwechter,
And Mr. Salwechter, how old a man are you?
65 years old,
And are you married?
married,
Got children?
4 children.
And how long have you lived in this Montgomery County area?
Oh, since 91.
Okay. And Mr. Salwechter, how do you make your way in life? What do you do for a living?
What I do is I have rental property. I have commercial and residential. I have about 16 residential properties and 22 units of commercial. I buy those properties through real estate, through tax sales, through mortgage foreclosures, any way I can find a good house to rent.
Okay. And did you attend a tax sale back in December of 2019 that took place here in Montgomery County, Texas?
Yes, sir, I did.
And at that tax sale, were you the high bidder, or was Salwechter Inc. the high bidder on a piece of property being sold for back taxes that was owned by NannetteCarley?
Yes, sir, right.
So, Mr. Salwechter, let me hand you what I have marked as Exhibit Number 1, and you recognize Exhibit Number 1 as being the deed whereby that piece of property was conveyed to you.
Yes.
Your Honor, this time I offer Exhibit Number 1.
Any objection to the deed, Ms. Carley, as being Exhibit 1?
Yes, I object to any evidence being presented that I haven't been presented with.
Okay, overruled.
So, if we could, sir, let's take a look at this deed. And Judge Santini, would you like for me to share it with you so you can see it, or how should I do it?
It doesn't matter. You can. I mean, I've viewed all the attachments and things already.
Okay,
So you can just go ahead and talk about it.
So ever so briefly then, Mr. Salwechter, that deed references a lawsuit where Tomball ISD sued Ms. Carley for back taxes, correct?
That's correct.
And there was a judgment rendered against Ms. Carley and in favor of Tomball ISD for those back taxes. Is that referenced in that deed?
That's correct.
And as a result of that, was there an order of sale out of the 284th District Court ordering this property that you purchased to be sold?
Yes, sir.
And was that property purchased by you as shown by, or by your company as shown by Exhibit 1?
Yes, sir.
And did that happen on December 3rd, 2019?
Correct.
Now, after you were the high bidder and after the Constable Jones, signed the deed, was it then necessary for you to go get a writ of possession in order to get possession of the property?
Yes.
So after you were the high bidder on the property and after the deed was delivered to you, was NannetteCarley still living in this property?
Yes, sir, she was.
And so was it then necessary for you to go to the district clerk of Montgomery County, Texas, to get a writ of possession?
Correct.
And so let me hand you what we have marked as exhibit number 2, and I ask you, do you recognize exhibit number 2 as a true and correct copy of the writ of possession you had to obtain in order to get possession, or for Salwisher Inc., in order to get possession of this property?
Yes, sir, it is.
And at this time, Judge Santini, I'll offer exhibit number 2.
Any objection, Ms. Carley?
I object to all of his exhibits. I have not been presented any of those.
Yep, these were all attachments to the application for TI, which was served upon you. Overruled.
And, sir, after you got the writ of possession, did you then carry it over to the constable Jones's office in order for them to remove Miss Carley from that property and put your company in possession of it?
Yes, sir, I did.
And approximately how long did they give Miss Carley to actually vacate that property?
Well, when I took it over there, evictions were still, could happen because of the COVID. But the day that they were going to present it, there was a moratorium then on evictions. It was probably 6 weeks later. I'm not sure the exact time that it was that they actually delivered it. When they did deliver it, they gave her 1 month, 4 weeks to vacate the property.
Okay. And did she finally vacate within that period of time?
She vacated. We had to be there at 10 o'clock with movers, locksmiths, and all the things that the constable required us to be there with. And we were. The constable gave her another 2 or 3 hours to get out of the house, but she did leave. Yes.
Okay. And we'll get to all of the movers and all the expenses in a moment. Now, let's just keep going. When you got possession of the property, describe to Judge Santini the condition of the property.
The outside of the property looked fine. The inside had a lot of trash, a lot of things that were left. The constable went through, said there was nothing there of value, and I could have possession of the property. The house is smoke in. Everything had turned yellow, and it had a strange, strong smell of smoke. But it just had a lot of items in there. All the carpet was stained. The pool is not in great shape. The other room, they had left a lot of items in the garage, outside, inside. There was an outbuilding in the back, and it was also full of stuff.
Okay. And part of when you took possession of the property, part of your cost include the cost of cleaning this place up.
That's correct.
We'll look at all that in one of our exhibits in a minute. Let's just keep going down this list. Now, did NannetteCarley request from you a redemption price of the property?
Yes, she did, but that was actually the second redemption request. The first redemption request was from her first lawyer.
And if you would tell Judge Santini that lawyer's name.
David Murphy.
And approximately when was it that Mr. Murphy made a request from you to give them the cost to redeem the property?
It was approximately, it was in the month of July. I do not have the date in front of me.
Okay. Well, let's do this. Let's take a look at exhibit number 3. And you recognize exhibit number 3 as a letter that was sent to Salwisher Inc. from NannetteCarley.
Yes, it is.
Now, you're familiar, are you not, with the requirements of the tax code of providing redemption costs to people that lose their homes at tax sales, are you not?
Yes, I am.
And the tax code bases your requirement to respond on so many days when you actually receive the letter. Is that right?
10 days.
Okay. And as a result of that, do you, in your usual course of business, make a note when you get these redemption letters the day you received it?
Yes, I did.
So let's take a look at exhibit number 3. Is that a true and correct copy of the letter that NannetteCarley sent to you requesting redemption process?
Yes, sir.
And is that something where you wrote on the date you received it?
Yes, sir, it is.
And attached to that also is the envelope from NannetteCarley, is that correct?
Yes, sir.
Is that a true and correct copy of that envelope?
Yes.
Along with the tracking history from the United States Postal Service, correct?
Yes, sir.
Judge Santini, at this time we offer exhibit number 3.
Any objection to your letter, ma'am?
I object to all evidence being presented today that I'm not allowed to view.
Well, you are allowed to view them, and this one was from you in your possession. So I'm going to overrule your objection.
So let's take a look at exhibit number 3. And is this a letter from NannetteCarley that appears to be dated June 29, 2020?
Yes.
And did you receive that on July 2nd, 2020?
Yes, sir, I did.
Now, in her letter, does she first say, you were first informed on June 2nd, 2020 by Montgomery County Constable Deputy Corporal Scott Hazelwood, and again by Attorney David Murphy, and a third time by Julie Scallop, it is my intention to exercise my right of redemption on the above property, and therefore I am requesting an itemized list of costs, along with receipts for such to be delivered to the above address. Is that what she wrote?
Yes.
Now, in there she makes reference to Mr. Murphy, right?
Correct.
And is that the attorney that had previously corresponded with you about getting redemption costs?
Yes, sir, it is.
And did you provide him your redemption costs?
Yes, sir, I did.
And then at some point, Ms. Carley communicates directly with you, and Mr. Murphy is apparently out of the picture. Is that the way you
That's the way I
Okay.
understand it. Yes.
And so let's then take a look at exhibit number 4. Is exhibit number 4, sir, and copies of receipts of your costs associated with having this house?
Yes, sir, it is.
And are those receipts things that are kept by your business, Salwisher Inc., in the usual course of its business?
Yes, sir, it is.
And is it the usual and customary practice of Salwisher Inc. to make the records that are contained within Exhibit 4?
Yes.
And were those kept in its ordinary course of business?
Yes.
And were those made by someone at or about the time of the information contained in that exhibit?
Yes, sir.
Your Honor, at this time we offer Exhibit number 4.
Okay. Any objection?
Yes, I object to all evidence he's presenting. I have not been privy to that today.
Overruled.
And so while we're going down that path, Mr. Salwish, let's jump over to Exhibit number 7. And if you would, I ask you to take a look at Exhibit number 7. And do you recognize Exhibit number 7 as a record that is kept by Salwisher Inc. in its usual course of business?
Yes, sir, it is.
And what is this record?
This is a record of all the expenses on this particular property.
Okay. And are these the type of things that it keeps in order to keep track of all the expenses it has on these properties that it owns?
Absolutely.
Is it made in the usual course of business?
Yes.
Is it made by someone with knowledge of the information contained in that record?
Yes, it is.
And was this made by someone with knowledge of the information contained in that record?
Yes, it is.
Your Honor, this time we offer Exhibit number 7.
Okay. Any objection, ma'am?
I object to all the evidence he's presenting today. I've not been privy to it. I am not privy to it today in these proceedings.
Overruled.
So, Mr. Salwisher, back at the time when NannetteCarley, and prior to that, her attorney, Mr. Murphy, had requested your information about the cost of redeeming the property, did you provide them the receipts that are contained in Exhibit number 4?
Yes.
Now, if we look to Exhibit number 4, you're going to see costs in here for things such as purchasing the property, $75,000 the first page, right?
Correct.
You're going to see in here cost of insuring the property, right, which is the second page,
Yes.
as well as the third. Then we go to the fourth page, as it's more information about insurance coverages. And those are all things required by the tax code to be reimbursed, right? And if we continue on, we're going to see where you pay taxes to Montgomery County for the years 2019 on the property, right? We're going to see where you pay taxes to Tomball ISD for the property for the year 2019, correct?
Yes.
And that's because at the time of the foreclosure sale, the foreclosure was based on taxes of like year 2017 and 2018, right?
Several years, yes.
But they did not include the year you actually purchased the property.
Yes.
And we're going to see within exhibit number 4, does it have the receipt where you had to pay to get rid of possession, to get possession of the property?
Yes.
For that $8. $8.
Yes.
And then the next page we're going to see where you had to give Constable Chris Jones $150 to have Ms. Carley forcibly removed from the property, correct?
Yes.
And we keep on, we're going to see costs to rekey the property.
Yes, sir.
And we're going to see costs to fix garage doors and things of that nature.
We'll change the code, no. Yes.
Is that necessary to safeguard the property?
Yes. Change the garage door opening.
Okay. Then we're going to see this Meridia Services. What is that associated with?
That was the first. I was not at the property the day that the writ of possession was there, but Meridia Services was.
And what was why were they needed to be there?
They needed to be. Constable said somebody from the company had to be there to supervise the movers, the locksmith, the gate, changing of the codes on the gate, and the garage door.
Okay, and these all costs you had to incur in order to safeguard the property.
Yes, sir.
We're going to continue on. You're going to see more expenses to Dawson Locksmith for $50.38. Just again, part of the things that you need to be redeemed.
Yes.
Or process to begin. There's where you're buying things, combination locks and stuff at Home Depot and chains.
Yes.
Was that necessary?
That was for the gate.
All right. Yeah. If you would describe to Judge Santini, the gate and how you get on and off this property.
There is the gate in front of the property is remote control. It's a lighting gate, big, heavy duty. The whole property is gated. In the back, there's another gate. This is a 2-acre property. The front acre, more or less, is a garage attached, a house, a pool house, and a pool in between, a big gate in behind, and then 1 acre approximately in the back with a couple of sheds. That also has a gate to it, which is just a manual gate, so it requires chains and locks.
Okay. And with these expenses, something necessary to secure the property?
Yeah.
Then we have this cost back here. And just to be clear, when we're talking about the property, it's the property described in exhibit number 1, right?
Yes.
And what is the physical address of that property?
26320 Pin Oak Drive, Magnolia, Texas.
Okay. And so there's a receipt here for K-Ron Services. Is that a company that provides roll-off containers necessary to clean all the junk out of the house?
Yes.
And if we continue on, you're going to see pictures of these containers, roll-off containers that are full of trash. Is that right?
Yes.
I believe there was 4 of those.
Four containers.
Now, before you threw that stuff away, did you get the clearance from the constable that it was stuff of no value, and rather than have a mover haul it off and store it at Ms. Carley's expense, rather than just throw it out?
Yes. The constable said there was nothing left of value. House was moved.
All right. Were there issues where you had to have work done on the plumbing by A Castle Plumbing?
Yes, sir. There were leak bolts in both kitchens. They were removed the refrigerator and turned off the water and the valves there, and one of the toilets.
Okay.
That's what needed work to have water turned on without leaking.
Was that all necessary to preserve the property?
Yes.
Then there's lawn maintenance where you paid to have the place essentially cleaned up outside. Is that right?
They went every week to maintain the yard.
And is that necessary to preserve the property?
Yes.
And now, does the property have a swimming pool?
Yes, it does.
What was the condition of the swimming pool when you got possession?
The water itself was clear. I didn't do any other work, but the pool does need maintenance on a weekly basis to maintain it.
All right, and has your company been paying the cost of doing that?
Yes.
Air Now Services. What is Air Now Services, and what do they do for you?
They do air conditioning work. House, when we were in the house was warm, a little warm, so I call the air conditioning service, come out and look at the air conditioning. There's actually 4 different air conditioners on the property. One behind the garage, which is not a window unit, something packed unit, did not work at all. That was replaced. The evaporator coil in the main house was leaking. The condenser outside was in great shape, so we replaced that. In the pool house, it was extremely hot. It was the old R22 Freon, which you can't even get anymore. That entire unit, inside and out, had to be replaced.
Okay. And was this all things that were necessary to preserve and protect the property?
Yes.
I object. Those were not necessary.
What's your objection, ma'am?
Those were not necessary, and they're not included within the law under covered costs.
Okay, I'm going to overrule your objection, and you'll be able to testify when it's your time, and you're able to question him when it's your turn. Thank you so
sir,
much.
I apologize.
Don't apologize.
And now, there was also, you incurred expenses for lawn maintenance, right?
Yes, sir.
Is that necessary to protect and preserve the property?
Yes, sir.
Did you have to buy a battery for the electric gate, I believe it was?
Yes, sir.
Was that necessary to preserve and protect the property?
Yes, sir.
For all the exhibits contained within Exhibit 4, money that was spent by Salwisher Inc. that were necessary to preserve and protect the property?
Yes, sir, it is.
Now, and Mr. Bays, I have a question too. I'm sorry to interrupt, but I'm looking at Exhibit 7, this list, itemized list, which just went through in Exhibit 4. And it's got a 25% surcharge. And 3421, it says that the first year, it says that Miss Carley has 2 years to redeem if it was a homestead. The first year is the 25% surcharge, the second year being 50%. So if the court finds it was not properly redeemed within the first year, would that $33,000 then turn into $66,000 approximately?
In the second year, yes.
Okay.
But additionally, Judge, there's additional costs that we're going to go over.
Okay.
And so the Exhibit 7 is more in time when Ms. Carley actually did her reported redemption.
Okay.
Okay. So if I may, Mr. Salwisher, let me hand you now this document that we've marked as Exhibit number 5 that purports to be a redemption receipt. Is this a document that you have gotten that relates to Ms. Carley's attempts to redeem this property?
Yes, sir. I got this from Montgomery County Records online.
And Exhibit number 5 is a true and correct copy of what is recorded in the real property records. Is that right?
Yes, sir, it is.
At this time, Judge Santini would offer Exhibit number 5.
Any objection, ma'am?
I object to all evidence presented today as I'm not privy to it. Not allowed to view it.
You are allowed to view it, and these exhibits have been attached, and you are allowed to view it. And I don't know if any. I know I didn't order any discovery for the purpose of this TI hearing, and I don't know if you've made any requests in discovery in the underlying suit, but I do know these documents were attached to the application. So with that, I'm going to overrule your objection to Exhibit 5.
So, Mr. Salwisher, so looking at Exhibit number 5, is this a document dated November 4th, 2020 by Tammy J. McCrae, Montgomery County Tax Assessor Collector?
Yes, sir.
And so, let's take a brief look in Exhibit number 6. Exhibit number 6, is this a document that purports to be an affidavit of fact that bears the signature of NannetteCarley, where the signature was verified or acknowledged before a notary public?
Yes, sir.
It's dated November 3rd, 2020, correct?
Yes, sir, it is.
Judge Santini, at this time I'll offer Exhibit number 6.
Yeah, any objection to your affidavit, Exhibit 6, which you referred to in your opening statement?
Well, I object, Your Honor, because I'm not allowed to view whatever it is you're viewing. I have no idea
not
what
doing
the court has been viewing today. I have not been able to see any of those documents today to see what the court is actually being presented.
Okay. You have been able to do it. You have copies of these exhibits already. So this is the same copy, the same affidavit that you referenced in your opening statement, and that's been attached as evidence, as exhibits, and at least the application for TI, and probably, I think, also in the petition. So I'm going to overrule your objection.
So, Mr. Salwisher, let's just take a quick look at exhibit number 6. At the top of exhibit number 6, does it say it's an affidavit of facts?
Yes, sir.
Despite saying that, if we look down at the bottom where the signature of the notary appears, do you see anywhere on this acknowledgement provision that it says that NannetteCarley has sworn under penalties of perjury or something to that effect, that she has knowledge of all the statements contained above, they're all true and correct?
This is not there.
Rather, it just says it was merely acknowledged before the notary, correct?
Correct.
So, this affidavit of fact, Exhibit 6, is dated November 3rd, 2020, correct?
Yes, sir, it is.
And this redemption receipt, Exhibit number 5, is dated November 4th, 2020, right?
That is correct.
Now, Exhibit number 7, does this Exhibit number 7 set forth the amounts that was owed to redeem the property as of November 4th, 2020?
Yes, sir.
No, sir. All right. And so, Miss Carley went in under this affidavit of facts and said $101,650 is all that was owed. Is that correct?
No, sir.
As of November 3rd, 2020, had you also paid the 2020 taxes to Tomball ISD of $7,803.34?
Yes, sir, I did.
As of November 3rd, 2020, had Salwisher Inc. also paid the 2020 ad valorem taxes to Montgomery County in the amount of $4,221.06?
Yes, sir, I did.
Now, looking at Miss Carley's number of 101,650, she provided nothing showing where that number came from, right?
Correct.
That's not the number you ever gave her, right?
No, sir, we never discussed anything about this. She asked for it by letter. It was sent to her by mail, and there were no discussions between that time and the day of November the 4th, when she came with her locksmith to change the locks.
Is it fair to say the only discussions you had with anyone on Miss Carley's side were your prior discussions prior to the time of her letter, that is exhibit number 3, was with that attorney, David Murphy?
That's correct.
And did David Murphy quickly bow out from doing any further work for her?
Yes, sir, he did.
All right. So, we also have our exhibit number 8. Now, if you would take a look at exhibit number 8 and tell the court whether or not you recognize exhibit number 8 as the most current maintenance record and all of the additional costs that Salwisher Inc. has incurred to date.
Yes, sir, it is.
And is exhibit number 8 a document that is kept in the ordinary and regular course of Salwisher Inc.?
Yes, sir, it is.
And is it itemized all of its costs associated with owning this property?
It is an itemized list of this property.
And are all those cost things that Salwisher Inc. is entitled to recover under the provisions of the tax code?
Yes, sir, it is.
And are those records kept in the ordinary and usual course of Salwisher Inc.'s business?
Yes, sir, it is.
And was it the business of Salwisher Inc. to keep and maintain that record?
Yes, sir.
Was that record made made by someone with knowledge of the information contained in that record?
Yes, sir, it
And
was.
was it made by that person at or about the time of the information contained in that record?
Yes.
Judge Santini, at this time I'll offer exhibit number 8.
Okay. Any objection on Exhibit 8?
Yes, I object to all the evidence presented today as I cannot see it.
Okay. And as I stated earlier, you've had the option to come to court in person, and you chose to go by phone.
I did not choose to,
Hold on.
Your Honor. I'm disabled. There is a
Okay.
difference.
The court is friendly to disabled persons, as is the courthouse. And you have an email which you have refused to give to my staff here, so we couldn't email you these things. So everything is sent to you via mail, and this is all through testimony. It's been proved up under business record affidavit and through testimony which you are listening to via phone. So I'm going to overrule the objection. You've had opportunity to get these documents, and I don't know if any discovery has been requested or not on your behalf. So, I'm overruling and admitting Exhibit 8.
So, looking at exhibit number 8, as of March 1st, 2021, is the redemption price now $205,306.36.
Yes, sir, it is.
And a large part of that increase is due to the fact that the tax code provides that in the second year, the redemption surcharge goes from 25% to 50%, correct?
Yes, sir, it is.
And so now,
See, I jumped the gun. I'm sorry. I should just let you guys. I should let both sides put their case on before I interject, which I will stop interjecting. Thank you.
you're doing great. Thank you. So the surcharge as of March 1st, 2021 is now $68,435.45. Is that correct?
That is correct. Yes.
Now, so Mr. Salisher, let's go back a little bit in time. And so you're over at the property. Miss Carley shows up with this document that is the redemption receipt, which is our exhibit number 4. I'm sorry, exhibit number 5, right?
Yes, sir, redemption receipt.
And the constable, what did the constable do, or how did the constable instruct Miss Carley to act upon showing up demanding that she had the right to possess the property?
His words, paraphrasing, were, "Do not step back on this property. If you do, I will have to arrest you." That was after the sheriff had already been there, and the sheriff would not make any ruling. He wanted the constable involved, and I think it was Constable Hazelwood that showed up, who has been at that property several times before.
Okay. And was she informed that just because you think you have the right to possession, you need a court to determine that?
Yes, sir. That's correct.
And so did she then file a forcible entry and detainer suit in Judge Manson's court over in Precinct 5 of Montgomery County?
Yes, sir, she did.
So
Let me go ahead and interrupt real quick. I'm sorry. I did notice another phone number has joined, 281-731-3953. Miss Carley, who is that? What's their name? Thank you.
That's my witness, Julie Shallop.
Okay. All right. Miss Shallow is going to need to step off because the rule has been invoked, meaning that one witness cannot listen to another witness's testimony unless they are a party to the case. And I'm sorry, can you please give me that person's name again? Thank you.
Julie Shallop.
Okay, Julie Shallop. Got it. Miss Shallop, if you don't mind stepping off until you are called, we'll have Miss Carley let you know when it's your time to testify. Thank you so much. All right, go ahead.
So, Mr. Salisher, take a look at exhibit number 9 and tell me if that is a true and correct copy of the petition for forcible detainer that was filed by NannetteCarley against your company and you.
Yes, sir, it is.
Judge Santini, this time I'll offer exhibit number 9.
All right. Ms. Carley, I'm assuming you object to number 9.
Yes, sir.
Overruled. 9's admitted.
And so, after Ms. Carley sued you and your company, Salwisher Inc., in Judge Madsen's court, was there a hearing held in Judge Madsen's court on December 28, 2020?
Yes, sir, there was.
Did you personally attend that hearing?
Yes, sir, I did.
Did Ms. Carley attend that hearing by phone?
By phone, yes.
And at that hearing, did Judge Madsen dismiss her lawsuit for want of jurisdiction?
That is correct, yes.
Mr. Salwisher, take a look at exhibit number 10. Do you recognize what exhibit number 10 is?
Yes, sir, this is the order of dismissal.
Is that the order dismissing the lawsuit of Ms. Carley?
Yes, sir, it is.
And is that something that was provided to you by Judge Madsen and signed by him?
Yes, sir, it is.
This time, Judge Santini, we offer exhibit number 10.
Okay. Same objection, Ms. Carley?
Yes, sir.
Okay. Overruled. 10's admitted.
And so, Mr. Salwisher, after Judge Madsen dismissed this lawsuit that Ms. Carley filed in Justice of the Peace Court, did Ms. Carley ever take an appeal from that ruling?
I'm aware, no, sir.
And if she had taken an appeal, that's something that you would certainly be aware of at this late date, seeing how this was dismissed back in December 28, 2020, right?
Yes.
Now, Ms. Carley testified or said in her opening statement that on January 19th, she went to the house.
Yes.
Right? And then she moved in, I believe she said sometime in February, correct?
Yes, sir.
Did she move in over your objections?
Yes, sir.
And despite the request that she vacate the property and your attempts to try to get the constables involved, has it become necessary for you to turn to this court, for this court to enforce the prior court's orders, essentially putting your company in possession of that property?
That is correct.
Is that why we're here today?
Yes, sir, it is.
Are you asking Judge Santini to enter a temporary injunction mandating that Ms. Carley vacate that property and she stay off of that property until further order of this court?
Yes, sir, it is.
Now, despite the fact that you have these court orders put in your possession, you've now been put in a unique position of having to come to this court to get what you're actually entitled to under the prior court orders, right?
Yes, sir, that's correct.
But nonetheless, in order for Judge Santini to enter a temporary injunction, it will be incumbent upon Salwisher Inc. to post some sort of reasonable bond to protect Ms. Carley in the event this is somehow wrongful. You understand that?
Yes, sir, I do.
And do you believe that a $100 bond would be more than adequate to protect Ms. Carley?
Yes, sir.
And so, but nonetheless, whatever Judge Santini decides, is Salwisher Inc. willing to post the bond as requested?
Yes, sir, I am.
And so, at the end of this hearing, or is that what you're requesting, that Judge Santini enter a temporary injunction removing Ms. Carley from the premises and putting Salwisher Inc. back into exclusive possession of the property?
Yes, sir.
Thank you, Mr. Salwisher. I'll pass the witness, Judge Santini.
Okay, Ms. Carley, it's your turn, ma'am, to ask Mr. Salwisher any questions subject to objections. And if there is an objection, just pause, and then I'll give you a chance to respond. Go ahead, ma'am.
Mr. Salwisher, when you were asked by David Murphy for an itemized list, you presented that list and it contained $33,000 approximately in maintenance costs. Is that correct?
Section Judge Santini, that calls for hearsay, and it also assumes facts that are not in evidence.
Overruled.
Mr. Salwechter, did you present an itemized list with over $33,000 in maintenance costs for the first 4 months of possession of the property?
Looking for the piece of paper to add it up, but there was a itemized list to David Murphy, the same list to you.
And did it contain over $33,000 in maintenance costs for the first 4 months? Is that a yes?
He's looking.
Okay, I can't see.
Totally maintenance cost, I can tell you the answer is probably no. The total to include on the list of maintenance, including taxes.
Well, just answer the question. So, are you saying that?
It was approximately that. I don't have it in front of me. I can't find it right now.
He doesn't know the exact number. He doesn't have it in front of him. Go ahead. Next question.
Okay, and in those costs, did you include costs for air conditioners
Yes.
and batteries for the gate
Yes.
and removal of the food forest?
Removal of what?
The food forest, the trees, the berms, and the swales in the back?
Burns and swells were removed, but that was not part of this maintenance cost, no. And the trees that you're referring to as a forest, they were as big as your finger and they were all dead. So yes, those were removed.
I'm having trouble hearing you, sir.
Yes, as far as the forest that you're talking about, there were probably a dozen trees there about as big as your finger, and they were all dead. And the burns and the swells that were removed in the backyard, that was not part of this maintenance cost.
Okay, thank you. Next question. Go ahead, ma'am.
On November 4th, when I returned to the property, did I present you with a stamped copy from the clerk of records stating that the property had been redeemed?
You did present a redemption receipt.
And it was stamped by the county clerk?
Yes.
Okay, so you were presented with a document that showed that I was the lawful owner according to Texas
No.
Property Code.
No. Well, not in my mind, but there was a redemption receipt.
So he says he got a redemption receipt, but he disagrees that it showed you're the rightful owner. Next question.
Okay, was my name the name on that document?
Yes.
Okay. So, on November 4th, you were shown a redemption receipt that was stamped by the county clerk, which according to Texas Property Code is notice to all that I am the rightful owner of the property.
Objection, Judge Santini.
And you were...
Make a legal conclusion.
Sustained.
I'm sorry, can you repeat the question, please?
No, I sustained it.
Oh.
So, Ms. Carley, I don't know if you heard, Mr. Bays objected because it calls for his client to make a legal conclusion, and I sustained that. About who the rightful owner is, that's up to the court to decide.
Well, the paper that he was shown was stamped by the county clerk, which according to the Texas Property Code is notice to all that I am the lawful owner. And Mr. Salwechter's indicated that he did receive that paper on November 4th. So then, after November 4th, did you enter the property?
No.
But your statement to this court states that you returned after November 4th and put no trespassing signs and chains on the gate. Was that not correct, or is what you're saying now not correct?
I said I did return. I'm sorry, maybe I misunderstood the question. Yes, I did return.
Okay, so after November 4th, when you were given notice that the property had been lawfully redeemed, you returned to the property, and what did you do?
I'm sorry, I'm going to object to the question.
Sustained. Sustained. I'm sustaining the question as it's misstatement of what the prior testimony was, and it's argumentative.
Okay. So, after November 4th, when you received the papers from me, stamped from the county clerk, which was noticed to you, you returned to the property and did what?
Same question. I put no trespassing on gates, and I put a chain and lock on both gates.
And at that time, did you also remove additional carpeting, the pool cleaning machine, and the pool remote?
No, did not remove anything from the property other than in July or whenever it was when we cleaned out the house. The carpet was moved in.
Okay. On the 19th, when I returned to the property to change the locks and take possession, did you call the constable?
On the 19th? No, I did not. I did see it on YouTube.
I'm sorry?
I did see it on YouTube.
Okay.
What did you see on YouTube? What are you talking about?
She had somebody there recording her and the locksmith on the property, changing the locks, somewhat taunting the Montgomery County Constable to come out and do something.
Oh, okay.
It's about 45 minutes.
And your papers submitted by your attorney state that on that day you called the constable and asked him to stop me from moving in.
I went to the constable.
Okay.
I did not call the constable. I went to the constable.
And what did the constable tell you?
Objection, hearsay.
Sustained.
Okay, well, it was submitted in the court record via Mr. Bays that the constable told you he would not be entering the property unless and until he was told by the county attorney that he could do so.
Object to the sidebar, Judge Santini.
Sustained.
Is this sidebar ex parte?
No, the sidebar means that it wasn't a question to him. It's just you testifying.
Well,
Sidebar means counsel testifying. You will have a chance to testify if you would like during your case, ma'am.
Okay. Well,
at this time,
I hadn't finished my question.
okay. Well, I sustained for hearsay, and then in your question you added the hearsay statements in there. So now you're backdooring hearsay, which is another sustained objection. So stick to question and answer, and just knowing that you will have a chance to testify when it's your turn.
Okay. Well, in his statement to the court, in his motion for injunction, Mr. Bay states that the constable was called on that day by Sal Wechter. Is that correct?
So, objection here.
Does-
saying
No,
does-
it just says that it was called. So were you just asking the question? Were you called by the constable? That would be the question. That doesn't contain any statement. Were you called by the constable?
Or, well, the question is, did he call or go see the constable?
On the 19th, you said, right?
Yes.
So on the 19th, November 19th, 2020, did you call or go see the constable, Mr. Salwester?
January, not November, the 19th.
Say that again? I'm sorry, I can't hear you.
It was January, the 19th, when she went to change the locks.
Oh, January 19th. Okay. Did you call or go see the
I did
constable?
call the constable. I didn't talk to anybody. That's why I went there. I went to the constable's office.
Okay. Next question.
And did the constable allow you access to the property?
No.
And why is that?
Objection requires someone to speculate what the constable did and didn't do.
Just saying.
Okay. Mr. Salwester, do you know what happened to the valuable items that were left on the property, such as the pool table, the shelving units, the industrial compressor inside a building, the diesel gas tank?
Object to the relevance, Judge Santini.
Sustained.
Mr. Salwester, did you remove items from the property that were not clearly trash?
Object to the relevance, Judge Santini.
Well, I think that may go to cost. Overrule. Did you remove items from the property that were not trash?
Yes.
What were those items?
An air compressor and a pool table.
And what did you do with those items?
Object to the relevance.
Sustained. Any items that you claim, ma'am, were yours? I think testimony is you had a month, 4 weeks, and then plus some extra weeks on top of that to get whatever you wanted to get your property in order, or your former property in order at the time. Go ahead. Next question.
Is it your testimony, Mr. Salwester, that when you took possession of the home? Well, let me ask you, Mr. Salwester, when did you take possession of the home?
The day that the constable moved you out, I believe it was June, on the calendar. I'm not confident of the date.
Next question.
And it's
It was the first Tuesday of June, whatever date that is.
okay. And it's your claim that the air conditioner didn't work at that time?
The air conditioner in the pool house did not work at all. The one in the pack unit or whatever it's called in the garage apartment room did not work at all, and the house was warm because of the leak, the loss of freon in the house.
Okay. No further questions.
Okay, thanks. All right, Mr. Bays, any other witnesses?
No, Judge Santini, we rest.
All right. Okay. Miss Carley, call your first.
I called Julie Shallop.
All right, you may want to get her back on the line. While you're working on that, let's take a 5-minute break. That way anyone who needs to use the restroom can use the restroom. I recommend muting your videos and things in the meantime, and we'll return in about 5 minutes with Julie Shallop's testimony. Thanks. Thank you. Lori is my court reporter, and I can't do anything without her. Otherwise, there's no record. So we have to wait for her to come back. She's here. She's smiling. I think
Judge Santini, you actually can, and I can tell you about this because we had a case when Tracy Gilbert's very first jury trial. We were like 30 minutes to a witness after lunch, and then here comes the court reporter. So.
I think I've started a hearing without her once, but it was like a second or two, and she's like, I'm not here yet. So we just redid what we already did. Miss Carley, ready, ma'am?
Yes.
Okay, Miss Shallop, are you there? Probably need to unmute. There you go.
I am. Yes.
Okay, great. Okay, we hear you just fine. All right, let me, would you please raise your right hand and tell me when your hand is raised?
My hand is raised.
Okay, do you solemnly swear or affirm the testimony you'll give in this case will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay, great. Thank you. Okay, Miss Carley, go ahead.
Miss Shallop, can you state when and how you met the defendant, Miss Carley?
I can. So, I met Miss Carley in the fall of 2020. A neighbor of Miss Carley's and someone that I knew from church called and kind of explained the situation and said, hey, is there anything, that you could do to help her? She kind of gave me the situation of what had happened. So anyway, I met Miss Carley and, she kind of just let me know what was going on with losing her home there on Pinoak Lane in Magnolia.
Okay. And were you there when Miss Carley was vacating the premises?
I was, actually. I was there a couple of days before she was finally moved out. I wasn't there the morning. I think the last day, if I understood it correctly, a sheriff actually showed up to the residence. I wasn't there that day, but I was a couple of days prior to that, helping her pack and move things to get out of the home.
Okay. So, were you there the day before the constables came to remove Miss Carley?
I was.
I object to the relevance. I don't know what this has to do with anything.
What's the relevance of this testimony, Miss Carley?
Well, Mr. Salwechter testified to trash on the property that he had to remove, and Miss Shallop was there the night before the constable came and has testimony in regard to that.
Okay. I'll allow that. Go ahead.
Okay. So, yes, I helped Miss Carley along with several other people that were there helping to pack and organize and get things out. I probably helped her the morning that the sheriff came to remove her from the property. That morning, I helped until probably about 2:30 a.m., and I finally had to call it quits. I was so tired. But at that time, pretty much everything was out of the house. There was a little bit of stuff left in the pantry that we were not able to get boxed up. There was a shed in the backyard that contained some expensive equipment, a huge air compressor and some other.
This is now non-responsive.
Let's go ahead and break it up to a little more question and answer instead of just a long-winded answer. That's what he's objecting to and what the rules call. It's not your fault. You're doing fine. It's not like normal conversation. It's got to be more of a back and forth.
Okay.
Yep.
Okay, so Miss Shallop, so you were there until 2:30 in the morning the night before the constable came, and was there any trash on the premises?
There was no trash. There was
a few things left in the pantry. I wasn't there for the final load. I know there was like a stack of boxes that we hadn't even been able to, put together and fill. But no, I did not see any trash on the property.
Were you specifically asked to remove the trash?
Objection, calls for hearsay. Stand.
I'm sorry, I didn't hear that, Your Honor. Calls.
Yeah, he objected to hearsay. What she was told outside of court, I sustained it.
Okay, so the question is, was I asked to remove trash from the property?
Did I?
No, there's no question before you.
Okay.
Okay.
Did I ask you to remove trash?
Objection, hearsay.
Sustained.
No, you did not ask me to remove trash, but we were picking up and filling trash bags as we were going along of things that you weren't going to take, and we did take a load of filled trash bags out of the property, yes.
I'm sorry, Judge King. I must object and ask that be stricken for there was no question. You sustained the questions. You answered anyway.
Sustained.
So you sustained the objection to the question.
Yeah.
Okay. Michelle, did you remove trash from the front porch to the curb?
I did. And also from the front porch to the back of a pickup truck where it was hauled away.
And is that all the trash you saw on the property?
It is.
And when you were on the property, did the property appear to be well maintained?
It was.
Did the property appear clean?
Yes, it was.
Did there appear to be damage inside the home?
No, I never saw any damage, and I was in every room moving boxes.
Okay. Did the carpeting appear to be good carpeting?
The carpeting.
Let me ask you this: did the
I'm sorry.
did
Object to the relevance, and furthermore object to her having any sort of qualifications to determine the fitness of the carpet. Furthermore, that there's been any sort of predicate laid that she had any examination or skills in determining the fitness of the carpet.
the plaintiff, Your Honor, the plaintiff.
Hold on, ma'am. Hold on. Let me rule. I'm going to overrule the objection. I'm taking it at face value, what it is, just based on her perception. I'm not taking this as expert testimony. If she saw anything with her eyes. Okay. Go ahead. You're asking about carpeting.
Did the carpeting appear to be damaged?
I did not see any damage to any carpet. It could have been cleaned. There was a little bit of staining in the master bedroom carpet, but it wasn't. It just looked like, traffic pattern and maybe needed to be cleaned, but there was no.
But there was no what?
There was no damage to the carpet.
Okay. And was the AC working when you were here?
It was.
Okay. And what do you do for a living, Ms. Shallop?
I am a local real estate agent selling residential homes.
Okay, so you routinely evaluate properties as a part of your job?
I do.
And how long have you been doing that job?
I've had my license for 7 years, and I was in the industry 2 years before that.
And as far as properties go, would you say that this property, Miss Carley's property, was well maintained?
Objection leading.
Overruled.
Yes, I think the property was well maintained.
And Ms. Shallop, for the record, it's Halloup?
Yes, P is in the color purple.
Yep. Yep. All right. Thank you.
Miss Halloup, did you see large items of value that still weren't loaded when you last left?
I did.
What's that? What's the objection?
It's vague as to what is meant by large, or the items of large value.
Overruled.
Okay. So it's your testimony, Miss Halloup, that the property was well maintained. There were no issues with any functioning items in the home as far as you could observe, and there was no trash left on the property when you left.
That's right. Yes.
Okay. No further questions.
Okay, Mr. Bays, go ahead, sir.
You, Judge Santini. So, Ms. Halloup, when you were at the property and doing your observation, in one of the bedrooms of the property, there was a stain on the carpet that's probably about 8-9 inches in diameter. That is a very dark black stain, correct?
I did not see that. Was that the master bedroom or the front guest bedroom?
So, the front guest bedroom now.
No, I did not see a large black stain
Okay.
on
And
that.
to the right of that large black stain, did you see a brown stain of about 4 inches in diameter?
In that same bedroom?
Yes, ma'am.
I did not see that. The only staining I saw
Okay, and you would agree, would you not, that if we show the court a photograph of this picture, a picture of that bedroom with a large black stain of some tar-looking material about 9-10 inches in diameter, that carpet would not be in good shape, right?
if it was not cleanable, then right, that carpet would not be in good shape if it was not cleanable.
Okay. And you did not get down and make any determinations about whether or not these stains that you did observe in the carpet were cleanable or not, correct?
The stains that I did notice in the master bedroom carpeting appeared to be normal traffic pattern stains, like when you come in the door and go around the bed or go towards the bathroom.
And when you left that night, do you remember being in the living room about, 6-8 rolls of wrapping paper, a large cardboard box, and some other packing materials strewn about on the floor?
When I left, there were some packing materials, but there were still people packing.
Okay. And you told the court that the AC was working when you were there, correct?
Yes.
How many AC units are on this house now?
I don't know. One for the main house. I don't know if there's one for the pool house or not. There's a little built-in AC in the storage room behind the garage. That room was already empty, so I didn't go into that one.
What is it that you did where you can come into this court and testify that the AC was working? What is that based on?
The temperature in the household that I noted a couple of days leading up to the time when Miss Carley finally was done and moved out of the household. I was there several times.
You don't purport to be an AC service technician, do you?
I do not.
And if AC service technicians determined that 2 of the units were completely not working, you would not have any reason to dispute that, would you?
I would not have a reason to dispute that other than what the temperature I noticed in the home when I was there.
Okay. And when you were in the home, did you notice how filthy the return air grills were?
Objection. Leading.
He's allowed to lead on cross-examination. Overruled.
Did I notice how filthy they were? No, I did not notice that they were filthy.
Well, ma'am, if they were filthy, you would agree that would be inconsistent with your statement before that the house is well maintained, wouldn't you?
I will say that lots of times people do not change their filters. So when I go into a home, lots of times homes are clean, but people have not changed their AC filters. They do not do it routinely. To me, that does not make a house filthy because they've not changed a filter.
Okay, let me ask the question though. You would agree that having a filthy AC air conditioning return grill
Objection. Calls for speculation.
Overruled.
Ms. Shallop, you would agree that someone having a filthy return air grill would be indication that the house is not well maintained, wouldn't you?
I would not. No.
Okay.
Again, I see it all the time when I go to speak with someone about selling their home or I take a buyer out to look at a home. That's not necessarily an indication. People forget to change the filters.
Now, when you left there that night, do you recall there being bags of trash beside the garage?
I did not see bags of trash beside the garage.
Okay. Do you recall there being like exercise equipment left behind in the house?
At the time I was there was still people packing and loading. I don't know what was left behind. I did not see at that time. I don't know what was still there. I did not see exercise equipment.
Do you recall the room that has the mini split air conditioning system having Lowe's buckets full of trash, priority mailboxes full of trash, trash strewn about the carpet in that room?
Are we speaking about the room behind the garage?
Yes.
Yes. I did not see that room.
Okay.
It was my understanding that that one had been emptied, and I did not see that room. We were focusing on the main house.
Okay. So you didn't go in that room, so you would not observe the piles of trash in that room?
I did not observe that room.
Okay. And what about the garage? Did you observe the garage?
The garage doors were open. There were people, loading things. There wasn't much left in the garage the last time that I saw it.
Okay. Did you observe steel cabinets in the garage that were still there when you were there?
I cannot say. I saw them at one point. I don't know if they were there when I left.
So, Mel, are you also having a conversation with Miss Carley while you're answering my question?
I am not.
I'm not speaking to anyone. No.
The only person I can hear having a conversation is Mr. Salwechter with you. I'm sitting in my kitchen.
And so, in this garage, do you recall there being units of plastic shelving?
I did not see them in the garage. I don't know if they had already been moved.
How about 2 or 3 old desks that are in bad condition in the garage?
I did not see those in the garage. Again, not sure if they had already been moved.
How about old garbage disposals in the garage?
I did not see that.
How about old furniture with some sort of old bedspread draped over the garage?
Again, I did not see that.
How about buckets of paint in the garage?
No, I did not see buckets of paint in the garage.
Did you go up and look at all the stuff that was strewn about in the attic?
I did not go in the attic.
lifted patio furniture outdoors on the patio?
No, when I left, there was nothing left on the patio around the pool. That had already all been moved.
How about piles of trash just outside the pool on the driveway?
Objection to
I
this
cannot-
line of questioning as to relevance.
Overruled.
Did you see that, ma'am?
I did not see piles of trash. No, I absolutely did not.
Okay, how about bags of trash?
Okay, well, you already asked me about bags of trash by the garage. Is this something separate you're asking me, or the same question?
Yes, ma'am. I'm now asking you about bags of trash along the driveway just outside of the fence to the pool.
Objection asked and answered.
Overruled.
I did not see that, no.
How about the laundry room? What kind of condition was it in?
Washer and dryer had been removed. I don't know if it had been broom swept. I think most things had been taken out.
Was there still a box full of cardboard material in the laundry room when you were there?
I do not remember seeing a box of cardboard material there. There was a box of boxes that we were making boxes out of to pack things up. I don't know if that ended up in the laundry room or not. I did not see that, no.
How about the kitchen? Did you observe the area in the kitchen where they had issues with the disconnecting refrigerator and trash being left there on the floor?
I did not see that, no. When I left, the kitchen was pretty much packed up. Boxes had been filled, sealed, had been, pushed out into the living room for loading onto the trailers.
Right. And it's your testimony that when you left, your view, being a real estate professional, this house was well maintained and no trash, correct?
When I left, yes, there was no trash.
I'll pass it with Ms. Judge Santini.
Okay, thank you so much. Ms. Carley, call your next.
I'd like to redirect.
Okay, go ahead.
So, Miss Shallop, you were there on the November 4th when Miss Carley tried to repossess her property after redeeming it with the county assessor collector and the county clerk of records.
Yes.
And were you there when Miss Carley went to the assessor collector and presented her affidavit?
Yes.
And was it accepted?
It was.
And she was issued a receipt?
Yes.
And the receipt was presented? Then did you witness that receipt presented to the county clerk?
Yes. And to my knowledge, it was recorded at that time.
Okay. And then did Miss Carley present that paper to David Salwechter, to the sheriff and the constable?
Yes.
Okay. And was Miss Carley asked to leave the property?
Yes.
All for your side.
Sustained.
Did you see Miss Carley have to leave the property?
Check to the relatives.
Did you see, but you did see Miss Carley present her papers of ownership to the...
I did see, yes,
Okay.
to Mr. Salwechter, to a sheriff, and to a constable as well.
Okay. And when the last time you were on the property, did you see a pool table on the property?
Yes, in the pool house or guest house. I'm not sure what you call that.
What was the condition of it?
Playable. You know, you could have easily played. I didn't note any damage. I would say it was playable.
Okay. And did you see in the backyard a 500-gallon diesel tank?
That's that can inject the relevance.
These were items of value that were left on the property that should have been stored by the constable. And Mr. Salwechter is asking for expenses to remove these items, which should have been removed and stored by the constable.
And that's her complaint with the constable. It has nothing to do with what we're doing in this lawsuit.
Well, it bears on Mr. Salwechter's expenses, as he states that he threw away these items, which he should not have.
Where does it show that?
In his filings with this court, he's claiming trash removal for all the items.
Okay. But does he list pool table and the tank?
I don't know that he specifically lists them, but I would suppose that that's what he used to fill up 3 or 4 dumpsters with. Because Ms. Shallop has testified there was no trash, so the only items left were items of value which were not able to be loaded.
Well, that's not what she testified to. She testified to when she left, people were still packing up, and when she left, the place looked in decent order. I'm paraphrasing, but it's my understanding that there were still people working when she left.
And it's my contention that items of value were left, which should have been removed and stored by the constable. They were not, and Mr. Salwechter is trying to claim payment for those expenses of removing those items.
Okay, I mean, I'll allow a little bit of this testimony. I mean,
so, Miss Shallop, did you see a 500-gallon diesel tank in the back?
I did not see that.
Did you see the building with the large compressor in it? Did you see any of the items in the outbuildings?
I did see the metal building with the compressor because I went out to look at it and say, what do you want me to pack up out of this? And so I did notice that building, the air compressor, and all the equipment attached to it in that building.
Mm-hmm. Did they appear to be trash?
That was not trash. It looked like very expensive equipment.
Okay. And the shelving units that you saw, did they appear to be trash?
The shelving units I saw did not appear to be trash.
Okay. So, when you left and they were still packing, did there appear to be much more that could be thrown away as trash from the time that you left?
No, there wasn't a lot left when I left at 2:30.
As far as inside the main house?
Right.
Okay. Okay. And then everything else that you saw on the property appeared to be of some value? Is that correct?
Yes.
Okay.
Yes.
Okay. And Ms. Shellop, when you testified about the AC filters, is it true that when an AC filter has been there for how long is an AC filter usually supposed to be in? A month?
I don't understand the relevance of what we're doing now. Objection.
Okay. Ms. Shellop, when, in your opinion, as a real estate agent, if an AC filter is ready to be changed, would it be dirty?
It would be dirty, yes.
Okay. So the fact that an AC filter is dirty is not evidence that it hasn't been changed regularly, is it?
Well, it just means that that particular filter hasn't been changed. I don't know the schedule of changing. I encourage people, to do it monthly, but most people don't.
Okay, if somebody changes it monthly, would it still be dirty when they took it out?
Sorry, Judge. Object to the relevance, and furthermore, what is her expertise?
It's sustained.
I'm just following up on the line of questioning that he opened about the AC filters, pointing to the property not being maintained.
It's sustained. According to Ms. Shallop, that thing can be filthy, and it doesn't have any bearing on maintenance. So.
Okay. No further questions.
All right. Mr. Bays, anything else?
No, Judge Santini.
All right. Ms. Carley, do you have any other witnesses to present?
I would like to testify.
Okay. Tell me when your right hand is raised.
It is.
Do you solemnly swear or affirm the testimony you'll give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. Go ahead, ma'am. You may testify.
So, it's my testimony that when I left the property, there was no trash. There were only items of value, which the constable should have removed and stored. The law says that the constable should remove everything left on the property and store it. Therefore, I should have no haul away fees or trash out fees from Mr. Salwechter whatsoever. Further, the law states that...
I'm sorry, Judge Santini. This is not testimony now. She's just arguing her case.
Yeah, you need to, yes, instead of arguing, tell us what happened. Tell me what happened, then you'll be able to argue later in a closing argument. But for right now, just tell me your side of what happened.
Okay, so I had been moving for at least 2 weeks prior, being disabled, not always able to physically move. So I had to wait until I could get help, which came 2 weeks before my deadline. We began moving at that time, and there was a lot of rain, so we weren't able to get trucks in and out. Before the constable showed up on the 2nd, at 10 a.m., we had been moving for 30 hours straight. When the constable showed up, there were still items of value left on the property, such as the pool table, the diesel tank, which should have been left on the property, the outbuilding, which contained the compressor, which should have been left on the property or removed by the constable and stored, a storage shed with multiple very expensive shelving units, and the ACs were in working order other than the one behind the garage, which doesn't need to work. It's part of the garage. The condition of the property was the property has been well maintained. And the cleaning expenses that Sal Wechter is claiming are not warranted by my testimony or Ms. Shallop's testimony.
And Judge Santini now, she's going back to arguing her case rather than stating facts.
Okay.
Objection.
Okay, that's it.
Okay. Any cross-examination, Mr. Bays?
No, Judge Santini.
All right. Do you have any other witnesses, Ms. Carley?
Not at this time.
All right. Do you rest your case?
I would like to make some closing arguments.
Yes. Before we get there, we need to close evidence. So do you rest your case as far as presenting evidence?
I've presented evidence to this court that I'm the lawful owner of the property, that it was lawfully redeemed, so that's...
Hold on. Closing argument is not evidence. So do you have any other documents or witnesses or evidence to present prior to closing argument?
Well, I present the paper that I sent in with my answer, which is the redemption papers.
So that's already admitted in evidence.
Okay, that's it.
Okay, so do you rest your case prior to closing?
Yes, sir.
All right, Mr. Bays, do you have any rebuttal?
Yes, Judge, I'm going to call Mr. Salwisher ever so briefly so we can put in evidence all the photographs, the condition of the property at the time he took possession.
Okay, Mr. Salwisher, you're still under oath.
Yes, sir.
So, Judge Santini, we have just emailed to the court reporter and I believe the PJ defendant's exhibit number 11.
Okay, and you can use the share screen so I can take a look at it. And you may want to lay some foundation too. So go ahead.
I certainly will.
I'm going to object to any further testimony about expenses, as these are not relevant to the property being properly redeemed. The law states the property has been properly redeemed.
Okay, well, that objection's overruled. This is rebuttal. He's rebutting Ms. Shallop's testimony as to the condition of the property. Go ahead, Mr. Bays.
All right. So, Mr. Salwisher, let me hand you what we have marked as exhibit number 11 and ask you to take a look at exhibit number 11, ever so briefly.
Yes, sir.
It's exhibit number 11, photographs taken of the property at or about the time that Salwisher Inc. got possession of the property.
I object. Condition of the carpet is not a maintenance repair which is allowed by law, so I object to relevance.
Overruled.
So, Mr. Salwisher, exhibit number 11. Do the photographs in exhibit number 11 fairly and accurately depict the condition of the house that you obtained through this constable cell at the time or at or about the time that you got possession of the home?
Yes, sir.
Now, one of these documents in here is actually not a photograph. Correct?
How many photos are in this?
There's 96 pages.
Okay.
And I believe 2 of the pages are not photographs. You'll confirm with me about
I object. I've seen none of this evidence.
Okay. All right. Overruled. If you gave the court your email, you'd be able to see what I'm seeing. And this is rebuttal. So this is rebuttal
Is the
evidence.
court trying to punish me for being disabled?
Ma'am, you specifically told the court through the staff attorney that you will not give the court your email, and before that you said that you do not have an email. So you told one of my staff that you do not have an email, and then you told my other staff that you do, you're just not going to give it to the court.
I told them both that I was having electronic problems.
The court. Ma'am,
yes, sir. I apologize.
Do not interrupt the court. I suggest you stop talking.
I apologize, Your Honor.
And for you to suggest that the court is punishing you for being disabled, you should be careful. That is a very serious accusation that you're saying to the court.
Yes,
when
it
we
is.
are accommodating you as best as we are able to, as best as you will allow us to, and you haven't even stated that you've ever requested discovery in this matter. And then to complain that you don't get discovery in this matter is not proper. It's not proper. So please don't interrupt the court when I'm speaking or making a record. We have made every reasonable accommodation for you. That is lawful.
I apologize, Your Honor.
Go ahead, Mr. Bays. 11 is admitted. Over objection. Go ahead.
Thank you. So the first photograph here, Mr. Salwisher, is that a stain with another stain that I believe is in the front bedroom?
In the front bedroom.
All right, let's see.
And for the record, 11 will speak for itself. That is a huge, big black stain. There's stains on the floorboards. There's crumbs and dead flies and stuff on the windowsill. And that was just one photo. Go ahead. Keep going.
All right, so let's keep going down here to this photograph 4. Is that stuff trash that was strewn about the home when you got possession of it?
Yes.
Let's continue down. Exhibit photograph 5. Is that some condition that required maintenance of the fence?
Yes.
Air conditioning filters in 6. Is that consistent with good home maintenance?
Yes.
Let's look at this air conditioning grill. That's the 7th photograph.
Disgusting. For the record, it's disgusting.
All right. Then more trash in the backyard shown in 8. And, the court can look through these. But, sir, this testimony that this house was well maintained and free of trash, is that consistent with what you found when you went over there?
No.
Is that consistent with these photographs?
These photographs are real. It's in the house.
Yeah. And now, sir, was there also all sorts of collections, boxes, whatever, left in this house up in the attic?
Yes, there was quite a bit.
Let's look at this garage picture. Let's picture 19. Is that
The garage is full. The garage is full of items.
It's
Full of items. I don't know how Miss Shallow could have missed this.
Also, garage.
Okay. And how about all these paint buckets in the garage?
Yes.
That's on, I believe, the 22nd page of the exhibit. And then we have up in the attic, is it full of trash, garbage?
And so,
So the 4 roll-off containers, is it this stuff that you threw in those containers?
yes, it is.
Now, and she talked about a diesel fuel tank. Was there a diesel fuel tank there?
There was no diesel. There was no fuel tank at all.
And sir, under environmental laws, could you even throw away a diesel fuel tank in a roll-off container?
No.
Thank you. Sir, the court can look through these, but these photographs clearly depict what you found when you went there, right?
Yes.
All right, thank you. I'll pass the witness, Judge Santini.
Okay. Any other questions, Miss Carley?
Mr. Salwechter, does it state in the property code that you can charge for AC units and carpet?
Objection. That calls for a question of law for the court.
Sustained.
No further questions.
Okay.
We rest and close, Judge Santini.
All right. You rest and close. All right. You rest and close, Miss Carley.
Do I get to make closing statements?
You sure do. But prior to that, I got to make sure everything's rested and closed. You rest and close your case.
I would like to state an objection to the entire line of questioning on this entire proceeding, but yes, I rest.
Okay, state that. Okay, so you rest and close. Prior to that, you made an objection to what now? What's your objection for the record? Because it wasn't clear what you were objecting to. Make that objection again.
I'm objecting to all the testimony as to the cleanliness of the home or property because
From which witness?
Sal Wechter.
So in his rebuttal?
Yes.
Okay, that's overruled. You called a witness, Julie Shallop, to talk about the condition of the house on 2 different dates. Overruled. All right,
Okay.
Mr. Bays, I'll give you all 10 minutes for closing arguments, and you get to open and close. Go ahead.
Thank you, Judge Santini. So what this comes down to is just really everything's out of order here. We should not be here. It should be Miss Carley that should have to come here because we have the right to possession. That right to possession came from that writ from the 284th District Court. And even if Miss Carley had a lawful redemption receipt, she still does not get the right to possession until she goes to a court and a court gives her that right. It is just basic Texas law that we do not allow self-help in these proceedings. If you have the right, if you say I sell you my house today and I don't move out, there's nothing you can do until you go to the proper court and get an order putting you in possession of the court and you have the law remove me from that home. And that is exactly what has happened here. My client purchased the property at a tax foreclosure sale. Miss Carley did not vacate. He complied with the law. He got a writ of possession. A writ of possession was served upon Miss Carley. The consuls went out of their way to give her more time than the law allows. I think the law allows 5 days. They gave her like 6 weeks. And they put my client in possession. Miss Carley then does not like the numbers, what it's going to cost to redeem the property. So on her own, she goes and sees Tammy McCrae, signs some document.
I object.
Not an affidavit. And that is a key point because you can only redeem property through this method by using an affidavit. An affidavit, Texas law is clear, must contain a jurat. A cursory examination of this document that purports to be the affidavit shows it lacks a jurat. She does not swear to anything. So she does not even comply with the Texas law on an affidavit. But even if she had, it would be incumbent upon her to go to the justice court to evict Sal Wechter. She understood that. That was made clear to her by all of the law enforcement involved in the proceeding. And so she does what she's supposed to do initially. She goes to Judge Maston over there in Magnolia in Precinct 5, and he says, no jurisdiction. Her remedy then was 2. She could have said, oh, you're right, I'm going to go see Judge Santini on some sort of injunctive relief to get possession of the property. Or she could have appealed to Judge Laird in County Court at Law Number 2. She did neither. She took the law in her own hands. She used self-help, and she went in, changed the locks, moved in, and has put my client in the unique position, the backward position, of the one having to come to this court to get this court to recognize that these orders are res judicata. Those ships have sailed, and she is just completely ignoring it and wants this court to allow her to continue ignoring the law. And so that's why we're here. We need the court's assistance. We're complying with the law. The court needs to recognize that she does not have the right to be in possession of that property. If she thinks she does, then there are remedies to her. she can come to this court and she can make a prima facie showing that she's right on the merits, that there's absolutely nothing wrong with what she did, that Mr. or Salwisher is going to eat, and perhaps the court will entertain that argument and put her in possession. I don't believe so. But that's what the law requires, is what should be done. But so because she's taken the law into her own hands with self-help rather than doing what she's supposed to do, we're in this backward position of having to come to the court and ask the court to reestablish possession in my client and remove her from the property. And so when the court examines the tax code, in particular 34.01, to sell the property, and then when you can get redemption of the property, there are some strict requirements. And she seems to want to quibble that Salwisher may be charging her for things that are not just. But there is absolutely no dispute that at the time she went to go do this redemption, Salwisher had already paid the Tomball ISD taxes, the Montgomery County taxes, for several $1,000s more. And those were not taken care of at all. Now, where she came for this number is a complete mystery. We have no idea. There's nothing in the records that she filed with Montgomery County that shows that. She just claims that's the correct number. But she never signed an affidavit. And that is the key to getting the redemption receipt. And that is why we have done what the law requires. We have come to this court to set aside this document that she has recorded in the real property records because it does not comply with Texas law. But in looking at the tax code, there is a interesting provision that the court should be aware of, and I think it speaks volumes about what's going on here. It is subsection H that provides that the right of redemption does not grant or reserve in the former owner of the real property the right to the use or possession of the property or to receive rents, income, or other benefits from the property while the right of redemption exists. And that's all we have here. She has the right of redemption. She has that for another, 8, 9 months, however long it runs. She has that right. She can redeem the property, but now it's somewhere north of $200,000. She can do it. But until she does that, she is not entitled to possession of the property. The law could not be more clear. She is not permitted to do what she has done. She has gone outside the law. She has used self-help. And that is the sort of thing that this court should not countenance.
What are you specifically asking in this TI?
We are specifically asking that the court enjoin Miss Carley from being in possession of the property and that she immediately vacate the property. And should she fail to immediately vacate the property, law enforcement is authorized to remove her from the property. That is what we're after. Thank you, Judge Santini.
Okay, that was 26. You have 3 minutes left. Okay, Miss Carley, go ahead, ma'am. You have 10 minutes.
I did not engage in self-help. What I did was I followed the Texas Property Code for redemption, and I lawfully redeemed the property as agreed the county assessor collector, because she issued the receipt, and the county clerk because they stamped the receipt. I've engaged in no self-help. I haven't sought self-remedy. I did not take the law into my own hands. I did not ignore the law. What I did was follow the Texas Property Code on how I could redeem my property when somebody was seeking unjust enrichment and trying to extort additional funds out of me that were not due. Cleaning and trash out is not allowed. Removing carpet is not allowed per the code. The code is very clear about what is allowed, and Mr. Salwisher stepped way beyond that in removing valuable things from the property. Even as his own admission, he removed my berms and swells and therefore changed the landscaping of the property, which he had no right to do. So nowhere in the redemption code is he allowed expenses for cleaning, for AC repair, for battery replacement, for hauling off the pool tables, outbuildings, compressor, the gas tank. All of those things should have been removed by the constable or left on the property. Mr. Salwechter had no right to remove them, and has caused me significant damage and expenses, even to move back in the home. So the home, regardless of what Mr. Bays claims, was lawfully redeemed. They were presented with notice of that. They did enter the property after that and trespass on my property, and now are trying to use the court system to extort more money out of me. The law states that in order to take someone's homestead, they are allowed a trial by jury, and I have not been given that right. Therefore, I cannot be removed from my property without a trial by jury. I submitted a motion to strike, and under that motion to strike, it must be judged with judicial notice rules, and therefore I've properly redeemed the property. Mr. Salwechter is seeking unjust enrichment to pay for disallowed improvements to the property, and I should not be removed from a property that I have now paid for twice. If Mr. Salwechter seeks additional funds, he should take that up in a separate suit. But it is not proper to remove me from a home without a jury trial after I have lawfully redeemed it and the papers have been presented to all parties. I'll reserve the rest of my time.
Well, you don't get another bite at it. So, anything else you want to say? Only the plaintiff gets to go open and close. You just get to do the middle. Anything else you want the court to know, to argue to the court?
That this court has no jurisdiction to remove me. I'm challenging the jurisdiction to remove me from my property. And until jurisdiction to remove me from my property without a trial by jury is determined, then I should not be removed from the property that I lawfully own and hold title to.
Anything else, ma'am?
No, sir. I asked the court to leave me in my home and not ask me to move. I've moved already. I've properly redeemed it. I presented the papers, and any other issues that Mr. Salwechter has with funding should be brought up in a separate action.
Okay. Mr. Bays, go ahead.
Thank you, Judge. Miss Carley tells you she has not done any self-help. That is just not even plausible. Miss Carley was instructed and understood that Mr. Salwester's company had exclusive possession of that property pursuant to a writ of possession of a 284th District Court. She believed she had the right to possession, but based on that redemption receipt, she was informed her only ability to get possession of real property in Texas is to get a court to agree and put you in possession. She attempted that. That is our Exhibits 9 and 10. Judge Masden heard what she had to say, dismissed her case for want of jurisdiction. She could have appealed that to Judge Laird. She could have come to this honorable court for the relief she seeks. She is the epitome of self-help. She did not get a court order to do what she did. She wants to complain about Salwisher is making improvements to the property. There is absolutely no evidence before the court of any improvements, none whatsoever. It is merely things that was necessary to do maintenance and upkeep. The property code, not the property, it's the tax code. The tax code in 34.21 requires Ms. Carley to pay costs, and cost is a very, very broad category. It is so broad it uses the term including but not limited to, or including property insurance and that sort of thing in 34.21 G2. Everything we have shown what item they are and how they lay out in the cost in our petition, and what provision of Texas law provides that to Salwisher as the cost. I'm sorry, Ms. Carley does not like it. That is the law. When you do not pay your property taxes, someone comes and buys your property, you must pay them the cost and all those other expenses, plus a 25% bonus for helping out the taxpayers of this county or whatever, and the second year a 50% bonus. That is the law. It could not be more clear. She has not complied. She has not complied with the law. That's why she lost her house. Now she's trying to get it back, and without complying with the law. There are remedies available to this woman. She needs to take advantage of those remedies and stop self-help. We ask the court to return possession of that property to Salwisher Inc., remove Ms. Carley from that property, and enjoin her from setting foot on that property until further order of this court. Thank you.
All right, thank you. All right, the court's ready to rule. I've prepared on this matter. I read the motions. I read the response. I saw the evidence. I listened to the testimony. And I've read the pleadings. I take judicial notice of the court's file. I agree with Mr. Bays that Ms. Carley does have a remedy. She's still in the redemption period. She has 2 years to redeem the property. The tax code makes it very clear, and so does the Supreme Court. So what was presented to the court as far as was the affidavit in proper form, was there a jurat or not, these are issues that have already been dealt with. This case is not unique in that aspect. So there is a case, this is actually from Montgomery County, and it has gone all the way up to the highest court of our state, the Supreme Court of Texas. That's the Mansions in the Forest LP and the Estates Woodland LP versus Montgomery County, 365 Southwest 3D 314. In that case, the affidavit had that the affiant acknowledged, they used the word acknowledged, in Exhibit 6 in this matter. That is the same exhibit that, this is the affidavit of facts from Miss NannetteCarley, and it says, this instrument was acknowledged before me on November 3rd, 2020 by NannetteCarley, signed Chloe A. Martinez, Notary Public, State of Texas in Montgomery County. The same exact language in the Supreme Court case. And in that case, it says, the record lacks any indication that the purported affidavit was ever sworn to. And when this happens, that case goes on to say, when a written statement does not meet this basic definition, it is no affidavit at all. That's the Supreme Court. That's the court I must abide by. Their rulings. I can't change their rulings even if I wanted to. I find that the elements for the TI were met in this cause. Probable right of recovery, the three elements, sufficient proof, and that there would be irreparable harm. I mean, we've already seen some of the condition of the property prior to possession. And so, Ms. Carley, I also looked at the case, the tax case that got you in this mess, the 1711 case. Let me get the full number, 1711-13325. In that case, there was an affidavit by you that the court found was not in proper order. Just like this case. It is the same exact mistake. And so I must follow the law. The under the law, the tax assessor shall take your affidavit as true. They had no choice but to take it. They weren't commenting on whether you were right or wrong. They had to take it. So, I am going to grant the TI. I'm going to order that the possession of the property return to Sal Wester. I'm going to order Miss Carley to vacate the premises. Do you have any recommendation, Mr. Bays? How many days?
I don't know how many days it took her to move in.
Judge, however long it took her to move in, that's fine. You can have that limited time to get out. We're not sure if it's 20 days. That's fine.
All right, we're going to give you 21 days to vacate the premises, and if you do not, I'm going to order law enforcement to remove you from the premises. I'm going to order a $100 bond, and this will be good until trial, and we have a trial date in this already, and just so we're all on the same page, let me see. Trial is set for September 7th, 2021. And I know Miss Carley said she wants a jury trial. At this point, it's a bench trial since no jury fee has been paid. So, if you want a jury trial, you need to pay the jury fee. All right, so you have at least 45 days notice for that. That is my order, and I will draft the TI.
And
Y'all are excused.
Your Honor,
Go ahead.
one question. You said who needs to file a bond?
Mr. Bays does. Mr. Bays' client.
Okay, and I will be filing an appeal on this.
Okay, that's your right. Nope, I don't hold that against you exercising your rights. Go ahead, no problem. All right, anything else?
And the court allowed how long, Your Honor, to vacate?
3 weeks. 21 days from today, I'm signing the order. Calendar days. 21 calendar days.
Okay.
All right. All right, y'all are excused. Thank you.